or maybe her.
What is the question of law? ऐसे नहीं हम अलाउ करते। क्वेश्चन ऑफ लॉ पता करके आइए, उसी में डिसाइड करेंगे कि किस दिन डिसाइड करना है।
कल में शिकायत
Last permission to mention one matter which is listed today at item number 15. This is the second appeal, and there are two IAs with this second appeal. One is for the stay of the execution petition, and the other is for formulation of additional substantial question of law, Your Lordship.
It is at serial number
15. So if it is not taken up today,
Sushmita. Yes, Sushmita.
yes.
I'm seeing you after a long time. How are you?
Yeah, I'm fine. So I was just requesting if a date can be given in the second week of. I think it will not be taken up today because it is an item.
It is at serial number? Serial number?
50. There are two IAs with the second appeal. I'm told that it should come under the heading under orders.
That's
Yes.
right.
But
Other side has responded to the IA?
No.
Not responded? You see, for the additional substantial question of law after admission and appearance of the party, we give an opportunity to the other side to respond to that if they want to. So that order can be passed today, and you can justify your appearance today. Who is the counsel for the other side? कौन?
Mr. Gautam Kumar.
तो बुला लीजिए ना उनको, बुला लीजिए। 4 बजे तो ऑर्डर्स करते ही हैं, ठीक है? ऑर्डर्स का ये अब तो हमको देखना पड़ेगा ना।
जी
कोई बात नहीं, सिर्फ आइए में उनको बोलेंगे to respond to that, and then we can hear it on whatever date suits you. Is that okay?
Under serial number 47, today list. I am correspondent. Award
Serial number
47, today list.
47. We can't do anything about it.
एक डेट लिखी है इसमें.
Date तो आपको जरूर मिलेगा. Date is not an issue. What is your urgency? You are for the appellant.
हम रेस्पोंडेंट हैं. अवार्ड हमारे पे.
Appellant कौन है?
एप्लांट अमर कुमार सिंह.
वो तो एडवोकेट है ना. उनके कौन पार्टी है? पार्टी कौन है? यूनियन ऑफ इंडिया है?
यूनियन ऑफ इंडिया.
फिर कौन है?
प्राइवेट पार्टी.
प्राइवेट पार्टी?
हम अवार्ड हमारे तरफ फेवर में हुआ है. वो इसको चैलेंज किया है.
अच्छा, he is claiming the portion of the award.
जी. एक डेट दिया है. इसमें आता है लिस्ट में टेकअप कभी नहीं होता.
टेकअप तो इतना तेजी से नहीं हो पाएगा ना. We are trying our best कि जितना टेकअप हो जाए.
कोई एक डेट दिया.
डेट तो आपको मिलेगा ही, ऑटोमेटिक डेट मिलेगा. यहाँ डेट के लिए थोड़ी बोलना है.
वो डेट वैसे तो मिलता है, तो आता है लिस्ट में, लेकिन टेकअप नहीं.
थोड़ा सा वेट करिए, थोड़ा सा ये सब जो पेंडिंग काम है ये सारी चीज़ों को थोड़ा निपटा लेते हैं, फिर आपका सुनेंगे ना. कुछ जैसे ये बैच है, ये सब जजमेंट सबको अपलोड हो जाने दीजिए, फिर आप थोड़ा सा नेक्स्ट टू नेक्स्ट वीक आप मेंशन करिए, हम सुन लेंगे. अदर साइड से कंसेंट लेके आएंगे, ठीक है? और कंसेंट ना दें तो भी बताइएगा. जो कंसेंट नहीं देता है उसका तो हम जरूर सुनते हैं. ठीक है? हाँ जज.
From supplementary list for judgment item 1, second appeal 391 of 2003.
This second appeal is allowed.
This case for final so item 2, first appeal 367 of 2018.
the respondents are relying upon Exhibit 4 and 12.
12.
Extensive arguments have been advanced on behalf of the parties on the point of quantum of compensation with regard to the rate at which compensation has been awarded with respect to the acquired land. It is not in dispute that 2,000 acres of land for military purposes in the 4 villages involved in this case were requisitioned in the year 1941-42, and then they have been acquired in the year 1971 by the Union of India under the aforesaid Act of 1952. As per the provision of the Act. That's all. As per the aforesaid Act of 1952, Section 8 deals with the principle and the method of determination of compensation. किताब लेके आई हूँ ना, उसमें सब मार्क नहीं मिल रहा है। And Section 7 deals with the power to acquire requisitioned property. Subsection 3 of Section 8 clearly provides that the compensation payable for the acquisition of any property under Section 7 shall be the price which the requisitioned property would have fetched in open market if it had remained in the same condition as it was at the time of requisitioning and has been sold on the date of acquisition. During the course of argument, it is not in dispute amongst the learned counsel for the parties that market value of the property is to be determined with respect to the date of acquisition. However, the learned counsel for the Union of India has specifically argued that the status of the property is to be seen referable to the date of requisition. And accordingly, they have submitted that on the date of acquisition, the property was of agricultural nature, and therefore the district land acquisition officer had classified the land in different categories under the agricultural head for 3 villages except Karan. On the other hand, it has been argued by the learned counsel appearing on behalf of the claimants that the market value of the property has to be seen on the date of acquisition, and therefore the value of the property referable to the date of requisition has got no reference. It has also been argued on behalf of the claimants that otherwise also the position and location of the property which existed on the date of requisition with respect to existence of national highway and state highway in the vicinity of the village continued to exist even till the date of acquisition, and thus there has been no material change with regard to the status of the property from the date of requisition till the date of acquisition, except that the property continued to be in possession of the Defence of India, and apparently certain constructions, etc., might have come up on the same property. the learned counsel appearing on behalf of the, with regard to the method of calculation of market value as adopted as considered and adopted by the learned arbitrator. It is the case of the learned counsel for the Union of India that Exhibit 10, which was exhibited by the claimants themselves, is relating to the rate chart prepared by the District Land Acquisition Officer. वही प्रिपेयर किए थे ना? District Land Acquisition Officer, and that being an admitted document on record could not have been discarded by the learned arbitrator. They have also submitted that the reference, they have also assayed the method of calculation, method of arriving at the market value of the property on the date of acquisition by referring to Exhibit 5, 7 and 8, which are of the period which are relating to acquisition of the year 1986-87 and 86-87, sale deed of dated 1963 and sale deed dated 13/11/1962 respectively. They have submitted that the backward and forward calculation which has been adopted by the learned arbitrator to come to the value of land in the year 1971 by deducting or adding 10% per year, as the case may be, is not in accordance with law. On the other hand, the counsel representing the claimants has raised serious objection in connection with rejection of Exhibit 4 and Exhibit 7
12.
Exhibit 12, Exhibit 4 and 12 by the learned arbitrator, and have submitted that the same have been wrongly rejected. With respect to Exhibit 4, they have stated that the same is the certified copy of the judgment of High Court in FA number 220 of 1977 within bracket R dated 6/2/1990. With respect to the land acquired under LA Act, Land Acquisition Act on 28/8/1971, where compensation was given at the rate of rupees 2,50,000 per acre, by observing that the property was situated near the railway station, bus stand, but the learned arbitrator has
What number 5 and 6?
yes, in relation to ward number 5 and 6, but the learned arbitrator has wrongly observed that with respect to the has wrongly observed by holding that the case in FA number 220 of 1977 within bracket R is distinguishable as the said land was situated near railway station and bus stand, and has ignored the evidences placed on record by the witnesses of the claimant that the property involved in this case were also nearby the railway station of the local area. Two railway stations of the local area. With respect to Exhibit 4, they have also submitted that the same was in relation to ward number 5 and 6.
5 and 6.
And the property involved in the present case is in relation to ward number
4.
4. And therefore, the property involved in this case was also in the vicinity of the property involved in Exhibit 4, and therefore, the same could have been a good parameter to come to a conclusion on the point of market value. They have also submitted that the compensation awarded in the said case was 2,50,000 per acre, and the compensation awarded in the present case is at the rate of 41,750 per acre, and there is a huge gap between both the figures. With respect to Exhibit 4, the argument of the learned counsel appearing on behalf of Union of India is that merely because the property in the same case was ward number 5 and 6, and the property in the present case is with respect to ward number 4, the same is not decisive and cannot be a parameter to hold that the property involved in this case was adjacent or nearby the property involved in Exhibit 4. They have also referred to the map which was exhibited, that is Exhibit 1, and have pointed out the location of the property involved in the present case, and have submitted that the property was away from the town area of Ranchi, though falling in municipal or area of Ranchi, and the property involved in Exhibit 4 was within the Ranchi town of Doranda. And I've submitted that though the learned arbitrator has cited only one reason in connection with proximity of railway station and bus stand, but otherwise also the Exhibit 4 is not fit for consideration when seen in the light of the location and position of the property. यही है आपका कहना है इसमें? With respect to Exhibit 12, the learned counsel appearing on behalf of the claimant has submitted that the same has been rejected by the learned arbitrator who has committed error on fact by observing that the land was situated at main Ranchi Chaibasa Road. Rather, the exemplar sale was located in Ranchi Chaibasa Road and not the land involved in Exhibit 12. They have submitted that Exhibit 12 is a judgment dated 25/1/1972 passed by Honorable Supreme Court in Civil Appeal number 661 and 1380/67 and 1885-1886 of 1967, and the same could have been used as a good parameter to assess the market value of the land involved in the present case.
Odd number 3.
They have also submitted that the property of Exhibit 12 was situated in Ward number 3, and therefore there is and therefore it is contiguous to Ward number 4 involved in the present case. The learned counsel appearing on behalf of the Union of India with respect to Exhibit 12 has submitted that there is no error in consideration of Exhibit 12 by the learned arbitrator by rejecting the same. They have again submitted that merely because the property is in Ward number 4 and the present property is in Ward number, the property was in Ward number 3 and the present properties are in Ward number 4, the same does not mean that the property was contiguous with that of the present land. They submit that otherwise also, upon perusal of Exhibit 12, the same is not fit to be taken into consideration in the present case. Submissions. with respect to the rate of compensation, the Learned Council for the Union of India has specifically referred to the judgment passed by the Honorable Supreme Court reported in bracket 2018 bracket close 13 SCC 96 para 11. Whose relevant provision has already been quoted above. यही आप लोग का सबमिशन है इसके बारे में? Upon perusal of the map, it has been exhibited as Exhibit 1. This court finds that the properties involved in this case, that is in village Gari, Khatanga, Lalganj and Sulu, are away from Ranchi town area, though they are situated on the national highway / state highway or in their vicinity.
मेरा थाना नंबर लॉर्डशिप 194 है, कोकर का 196 है, दोनों सटा हुआ है।
Koker is not shown within the Ranchi town area. Koker is not shown within the Ranchi town area. The Thana number of Gari is 194, Khatanga is 179, Lalganj is 171 and Sugnu is 170. And the national highway passes right through the village Gari. Between Gari and Khatanga, there is Thana number 180 Hotwar, and Khatanga, Lalganj and Sugnu are one after another, and the state highway is passing through their vicinity. यही है ना?
ये खटंगा और
The
लाहौर
state highway is joining the national highway.
नॉर्थ
यही है आपका? So far as the oral evidence is concerned, the witness number 1 on behalf of the claimants has stated that the property of all the 4 villages are of same nature and was not fit for cultivation, and in the open market the property was more than rupees 2 lakhs per acre, as the entire property was fit for construction of houses. He has also stated that all the 4 villages are nearby the National Highway number 33, and therefore the value of the land was very high, and they have been given much less compensation. He has also stated that adjoining to Gadi, there is Poker industrial area where number of commercial activities are taking place, and in the year 1971 all the 4 villages were having the status of semi-town area, and all the 4 villages were to be considered, are fit to be considered as urban area, and therefore the rate should be fixed as urban area and not agricultural land. He also stated that in the year 1971, the acquired land was fit for construction of houses, and therefore the compensation should be adequately fixed. There were only few sale deeds available with respect to the properties in the village, as large number of population is belonging to scheduled tribe / backward classes, and for selling the property the permission of the government is required. The location of the property near the National Highway number 33 was emphasized for the purposes of arriving at the market value. It was also asserted that a distance of 4 to 5 kilometers from Ranchi town has not much bearing, as the Ranchi town was growing and had grown till the school, namely Vikash Vidyalaya, which is situated 5 kilometers to the north of the land in the present case. It was also stated that all the 4 villages formed part of the municipal area and they form a part of Rakhi town. The 4 villages are adjoining to Rakhi town and therefore they should be treated as town area. It was also asserted that there is river adjoining the villages and in the vicinity there is high density of population and there are market, bank, school, hotel, petrol pump, etc. There was also ward number 7 near National Highway 33 where number of commercial activities is carried out and has electricity and has facilities of electricity, water and they had also stated that between Khatanga and Lalganj there is a road joining, there is a state highway number 32 which joins to National Highway number 33 and the state highway was there even in the survey of 1932. And the value of the land so acquired in the present case and it was also asserted that the value of the land acquired in the year 1971 along the side of the state highway was rupees 2 lakhs per acre and are fit for construction of houses. It was also asserted that since the village has good irrigation facility due to the adjoining rivers, the villagers they take 4 harvests in a year and the value and the income from the land is rupees 20,000 per acre. There is also BIT Mesra Engineering College and other organization to the north of the villages at Getlatu village. It was also asserted that all the 4 villages are adjoining to each other and there is nearby Tatasilvai village where there are number of commercial activities. And name of few industries have also been mentioned. And it has been specifically stated that there is Tatisilvi railway station in the nearby, and towards the south there is Namkum railway station, petrol pump, cement depot, petrol depot, cement depot, National Highway number 33, and the government has acquired land for National Highway number 33, whose value is 3 lakh rupees per acre, 30 lakhs rupees per acre. It was also asserted that 2-3 kilometers away, for the purposes of construction of Ranchi Club, in the year 1954, the land was acquired, for which the compensation was fixed at the rate of rupees 1.35 lakhs per acre. And the Doranda area in Ranchi town is 4 kilometers away, where the compensation was given at the rate of rupees 2.5 lakhs per acre. It was also asserted that the property which was acquired by defense in Kutiyattu village in the year 1986, the arbitrator had given compensation at the rate of rupees 2 lakhs per acre, on which which was approved by the High Court. Kutiyattu village was 12 kilometers away and half mile away from National Highway 33. He has stated that the Namkum railway station is 3 to 4 kilometers away towards the south. Ranchi town has lot of commercial activities. The district land acquisition officer has wrongly arrived at the value of the land of all the 4 villages. He also claimed that 30% solatium and 15% interest per annum is required to be paid in this case. It was also asserted that the manner of valuation of the land was not acceptable, as the value has to be ascertained considering the urbanization and the classification of land lost its relevance way back in the year 1971, and the property was fit for construction of houses. The military has constructed huge buildings over the property. And therefore, the aforesaid aspects are required to be considered by fixing the market value of the land.
रांची 1912 से ही राजधानी था समर का। इसके
He has also stated that Ranchi was the summer capital of the then state of Bihar since 1912. This witness has been cross-examined by the respondent number 1 as well as respondent number 2. With respect to the valuation of the land, the cross-examination question number 15. नहीं 15 क्वेश्चन नंबर कौन सा इंपॉर्टेंट है बताइए? क्वेश्चन नंबर 19. Twenty,
20, 21, 22,
21, 22, 23, 24 are relevant. ठीक है? क्वेश्चन नंबर 19 to 24 पुट कर देंगे आंसर. ठीक है? क्रॉस एग्जामिनेशन है ऑफ फर्स्ट विटनेस ऑफ द क्लेमेंट बाय रेस्पोंडेंट नंबर 2. उनका इंटरनल पेज 7 से क्रॉस एग्जामिनेशन शुरू होता है और रेलेवेंट है पेज 9 and 10. Similar statements have been made by witness number 2. एक ही ऐसा है ना?
जी
As that of the witness number 1 on behalf of the claimant. He has also been cross-examined on behalf of respondent number 1 as well as respondent number 2 with respect to the valuation of the land. The question number 2 और कौन सा बताइए? From the cross-examination by respondent number 1 is important. And so far as cross-examination by respondent number 2 is concerned, the question number 4, 5, 4 and 5 important. 4 and 5 are important, which are quoted as under. इसमें respondent number 1 के cross examination से question number 2 लेना है, and respondent number 2 के cross examination का question number 4 and 5. ठीक है? So far as witness number 3 on behalf of claimants is concerned, he has also deposed on similar line as that of the witness number 1 and 2. And so far as cross-examination by respondent number 1 is concerned, the question number 3 8 9 are relevant. So far as cross-examination by respondent number 2 of witness number 3 is concerned, the question number इसका तो कोई रेलेवेंस नहीं है बहुत ज़्यादा, नहीं है ना? इसको छोड़ दीजिए. There is one more witness on behalf of the claimants, that is witness number 4. He has also deposed on similar lines as that of the other witnesses of the claimants. And with respect to valuation, the question number seven, 8, 9, 14, and 15 are relevant, which are quoted as under. So far as the upon perusal of the evidence of the witnesses produced on behalf of the claimants, it is clear that they have deposed in the same lines, and the evidence revealed that the property involved in this case is nearby National Highway 33 and stroke or nearby the State Highway number 32. State Highway का नंबर दिया है.
State Highway 32.
State Highway number 32 and the state highway also joins the national highway. It is nobody's case. No, also joins the national highway. There are rivers nearby, and the railway station is situated around 3 to 5 kilometers. Namkum railway station is situated around 3 to 4 kilometers away. It is also clear that though this property is not within the Ranchi town, but it is certainly within Ranchi municipality.
ये जो कह रहा है लॉर्डशिप
And
सेंटर ऑफ द विलेज से 4 किलोमीटर
And is towards the outskirts of Ranchi town. The map as produced and exhibited before the learned arbitrator reveals that between Ranchi town and the nearest village towards Ranchi town, that is Gari, there is an area called Kokar. And the other 3 villages, Khatang, Lalganj and Sugnu, is adjoining each other, but Gari is separated from Khatanga by an area called Kokar. Correct? Gari is, the national highway passes through Gari, and state highway joining the national highway is passing through Khatanga, Lalganj and Sugnu, when all the 3 villages which are contiguous are taken together. So far as the deposition of the witness produced on behalf of Union of India are concerned, they have produced only 2 witnesses.
Three.
They have produced 3 witnesses. DW1 is SDO Roman 2 in Office of Defence State, who has been working since July 2013. That is much after the date of acquisition of the land. With respect to the location and valuation of the land, he has deposed that vast tract of land in 4 villages involved in the present case were acquired in the year 1970 for military purpose, and total area is 1846.99 acres. The compensation has been paid as per prevailing market value. it has been asserted that the abandoned land were acquired for the purposes of defense, and the acquisition and at the time of acquisition the area was underdeveloped, there was no market nearby, and the district also had very less population. There were no school and colleges nearby. This witness has been cross-examined. And during cross-examination, he has stated that he had not visited the 4 villages during 1940 to 1970, and that he had joined the present post just 6 months back. He was cross-examined on 24/11/2013. He had visited the 4 villages 2 to 3 times, but he could not say when did he visit. This witness asserted that the 4 villages had developed after acquisition. He has been asked as to whether he is aware about the basis of valuation of land of the district land acquisition officer, to which he responded by saying that it was done as per norms. It was suggested to him that the valuation should have been at least rupees 2 lakhs per acre, to which he stated that he could not say anything and he was not present at the time of payment of compensation. The evidence of this witness revealed that he has not much knowledge about the value of the property at the time of acquisition, nor he had any idea about the basis of valuation of the property. So far as the DW2 is concerned,
एक बार छूट गया first. However, from the record, I got knowledge about the said acquisition of 4 villages, example Khatanga,
Achha.
Lalganj, Sumnu and Gadi,
That's-
between Ranchi town
That's
and
it.
said 4 villages in NH 33 is situated. Ye record
This
se
witness, important, this witness during the course of cross-examination had stated that from the records he got knowledge about the acquisition of the 4 villages involved in this case. Between Ranchi town and said 4 villages, NH 33 is situated. Although he has deposed in connection with the location of the property, but has no idea about the valuation of the property. So far as DW2 is concerned, he is the SDO Roman 3 in the Office of Defence State and claims to have been working at that position since November 2010. With respect to the location and valuation of the property, he has stated in para 9 that compensation was paid to the land users, taking into consideration the prevailing circumstances and market value of the land in question at the time of acquisition in the year 1970. And that the district land acquisition officer had submitted photocopies of the relevant records of all the 4 villages which were required to be taken into consideration by the joint tribunal. He has further deposed that abundant land was acquired for the purposes of defense, and at the time of acquisition the land was underdeveloped. There was no market near the area. Ranchi was also a district only, having very less population, no school and colleges were nearby the area. During his cross-examination, this witness has stated that he could only speak on the basis of the records, and he has further stated that the district land acquisition officer had categorized the land as Dhan 1, Dhan 2, Dhan 3 and Tar 1, Tar 2, Tar 3. He has also stated that NS 33 runs between Ranchi and the 4 villages in question, and that he was not present at the time of payment of compensation. A suggestion was given to him that the compensation was very low and the valuation was at least rupees 2 lakhs per acre, to which he stated that district land acquisition officer and the deputy commissioner are the competent persons. This witness also has no idea regarding the valuation of the property, but he has deposed with regard to the position of the property acquired and has categorically stated that NS 33 runs between Ranchi and the 4 villages in question. The district land acquisition officer has been examined as DW3.
Not seen.
DW3. And
Again,
he has simply stated that he could depose only on the basis of the relevant records with respect to the 4 villages, and that he was in the said post only since December 2012. During his cross-examination,
para 6.
just a minute. At paragraph number 6, we have stated that the said villages are near Ranchi town, divided by NS 33, and Gari village is at present under Ranchi Municipal Corporation, and the land of the aforesaid villages have been acquired for the purposes of defense. And he did not know whether the buildings have been constructed on the land of the aforesaid 4 villages by defense or not.
Para 8.
He has further stated that the state government had fixed different rates for different classes of land through the concerned deputy commissioner of the district. The rate of land with respect to village Gari effective from 1/1/2013 is fixed at rupees 1,56,000 per decimal for residential plot, rupees 1,88,186 per decimal for the roadside plots rupees 3,13,643 per decimal for the land for commercial purpose and rupees 3,76,372 per decimal for the plot on the side of the municipal road. Likewise, the rate of other villages, namely Subnu, Lalganj and Khatanga, was also fixed with effect from 1/1/2013. He has stated that village Gari was within ward number 4 of the municipal corporation. बाकी village के बारे में नहीं बोला.
वो इतना डेवलप था कि अभी सब नगर निगम में
बाकी villages के बारे में नहीं. Only village
गाड़ी था
village Gari.
इतना डेवलप था कि
अभी सब है, लेकिन at that point, during the course of argument, the learned counsel for the claimant, upon a query of this court, has stated that at that relevant point of time, village Gari was in ward number 4 of the municipal corporation, but so far as the other 3 villages are concerned, they were not forming part of municipal corporation, but at present they all form part of municipal corporation. Para 11. This witness
10 and 11.
10 and 11. This witness has also stated that at present the area of the 4 villages appear to be developed at their near Rathi town, and he did not know whether they were developed at the time of acquisition. He did not know as to whether PWD road connecting NH 32 and 33 passed through the village Khatanga and Lalganj. However, upon perusal of the copy of the map, it appeared that the road connecting NH passed through the village Khatanga and Lalganj. The suggestion given that the rates have been fixed arbitrarily and without considering the prevailing market rate has been replied by stating that the compensation has been paid on the basis of prevailing market price. He has further stated that compensation has been paid adequately by defense to the land users at the prevailing market rate existing in year 1971, and at present there was no outstanding amount to any land users. This witness has referred to the circle rate of the area which was prevalent in the year 2013, but has no idea about the market rate which was prevalent at the relevant point of time of acquisition of land in the year 1971. Further, this witness has deposed with respect to the location of the property acquired, and it is not in dispute from the evidence of this witness also that the property involved in this case is in the vicinity of National Highway number 33 and State Highway number 32, which corroborated with the map which was furnished by the claimant. Correct?
एक चीज बोलना चाहेंगे लॉर्डशिप, अगर 2013 में अगर उनका सर्कल रेट को देखा जाए तो नियर अबाउट 4 करोड़ रुपए आता है 40 साल के बाद।
At this, the learned counsel for the claimants has submitted that the circle rate has been shown of the year 2013 with respect to per decimal, and if it is taken with respect to per acre, the value would be much higher and running into crores of rupees.
सर्कल रेट के हिसाब से कोई जमीन खरीद बिक्री नहीं होती है लॉटशिप में, तो सब
He has
सारे
also
लोग
submitted that.
सारे लोग जानते हैं.
He has also submitted that the circle rate has no relevance. Otherwise, also has no relevance in view of the fact that the property has to be valued on the basis of market rate and not circle rate.
सारे लोग को पता है लॉटशिप जो सर्कल रेट है उससे ऊंची दाम में ही लोग खरीदते हैं.
In view of the in view of the deposition of the witnesses, though the location of the property is quite clear, when seen in the light of the map, but so far as the market value is concerned, nothing concrete comes out of their evidence. Okay? Therefore, what remains to be considered is the documentary evidences which were filed by the respective parties before the learned advocate. The award of the learned arbitrator has been discussed at length in the aforesaid paragraphs. The learned arbitrator has enlisted the claimant's documents which have not been relied upon by the arbitral tribunal. They are Exhibit 4, 6 and 12. With respect to non-reliance of Exhibit 6, the claimant has no objection, but they have heavily relied upon Exhibit 4 and Exhibit 12 and have submitted that these two exhibits could have been the parameter to determine the quantum of compensation, and if these two exhibits are taken into consideration, then the compensation would be much higher. So far as Exhibit 4 is concerned, this court finds that the land involved in the said case is, this court finds from paragraph 2 of Exhibit 4, which is a judgment passed by this court in connection with land acquired under Land Acquisition Act, for which notice under Section 4 was issued on 28/3/1971.
शायद 8 है, 8.
1971. Page number 2.
28/8/1971 है शायद.
हाँ, so 28/8/1971, which was situated in ward number 5 and 6 of Doranda within Ranchi municipality, and a declaration under Section 6 was made on 15/11/1971. when this property is seen in the map, this court finds that कहाँ लिखा है डोरंडा म्यूनिसिपैलिटी 223
टॉप में लॉर्डशिप राइट हैंड साइड में एक अलग से
हाँ।
दिया गया है डोरंडा नीचे में हम थाना नंबर 198 के लगभग में
196
180 195 179 ऊपर है 196
उधर तो फिर इधर ही है
उनका जो है वो गुलाबपुर 197 उसके बगल में हम हैं और यहाँ डोरंडा नीचे में 223
नीचे में है ना
223
the same falls in
नगर निगम नहीं सर
थाना नंबर 223
हाँ 223
223 which is within Ranchi town, which is shown as within Ranchi town, and the same is certainly much away from the villages which are acquired and involved in the present case. काफी दूर है डोरंडा से हम लोग जाना
हाँ
काफी दूर
लॉर्डशिप हम लोग नगर निगम में
that's right
अगर एक कोच में किसी को सीट 1 मिला है कि 72 है तो एसी 2 में ही आएगा ना सारा कोच
लेकिन दूर
दूर है लेकिन वो ठीक वो भी नगर निगम में लॉर्डशिप हम भी नगर निगम में कुछ तो आप फुलफिल करते होंगे ना कैरेक्टर को नगर निगम का
नगर निगम सिर्फ गाड़ी
हाँ तो
बाकी सब बाहर
हाँ लॉर्डशिप वही मेरा कुछ तो कैरेक्टर हम लोग फुलफिल करते
it
होंगे तभी
is
तो नगर
also much away
निगम। और
from
अगर गूगल से
गाड़ी
सर्च किया जाए तो बहुत अधिक नहीं है
it
ये
was
तो ये
also
अधिक
much
नहीं है
away from Gari, which is Thana number 194, and as per the deposition of the witnesses, Gari fell in ward number 4 of the Ranchi municipality at the relevant point of time. And certainly it is much away from the other 3 villages, namely Khatanga, Lalganj and Sugna, which were falling,
बहुत अधिक दूर नहीं
which is
बहुत अधिक
अब
दूर
तो
नहीं।
अमेरिका भी दूर कहाँ है?
नहीं गूगल से अगर देखा जाए लॉर्डशिप तो तुरंत बता देगा कितना डिस्टेंस में है तो
जुपिटर से देखें
ये
तो
मत लिखा दीजिए मच एरिया डिस्टेंस तो
ये
बहुत
मेरा
कम है।
फाइंडिंग है, इसमें आप कुछ नहीं बोल सकते।
लॉर्डशिप इधर हम्बल रिक्वेस्ट लॉर्डशिप ये ईयर टू ईयर बहुत कम है लॉर्डशिप
कोई बात नहीं। Which is एक सेकंड, which is थाना नंबर 179, 171 and 170. This exhibit 4, from further perusal of exhibit 4, this court finds that the appellant, who were the claimants in the said case, had argued that the land involved in the said case was situated in the heart of the town and was commercial area. And it was also asserted that the same was very near to the railway station and depot belonging to Bihar State Road Transport Corporation and had great potential value as it was on the side of the main road. And in fact, the land was acquired for the construction of overbridge. ये अपना main road वाला overbridge है क्या? कौन सा overbridge है? वही होगा?
स्वर्णरेखा नदी
अच्छा
स्वर्णरेखा
स्वर्णरेखा।
नदी के ऊपर
टाउन से करीब बाहर है।
जो आपका सबमिशन था आपको पैरा 5 से लिखा, पैरा 5 से लिखा। कौन सा? पैरा 5 एग्जिबिट 4 का पैरा 5 देखिए।
ये इस ओवरब्रिज का ब्लॉक से बात है।
हमको नहीं पता पैरा 5 में जो दिख रहा है अकॉर्डिंग टू द अपीलेंट्स द लैंड इन क्वेश्चन इज सिचुएटेड एट द हार्ट ऑफ द टाउन, है ना? The High Court in the said judgment also observed that the concerned court did not accept the valuation with respect to Exhibit 5 by A only on the ground that it was 3 years, more than 3 years prior to the date of notification issued under Section 4 of the Land Acquisition Act. The Honorable Court was of the view that the approach of the learned trial court was not correct. And the Honorable Supreme Court has already held that that in land acquisition proceeding, computation should be made on the basis of CVs which were executed in respect of the land at about the time when the notification issued under Section 4 of the Act was issued. However, in absence of such a document, the court has to consider all the available documents, and in computing the market value of the property, some amount of guesswork was in it. And in that background, the Honorable Court held that Exhibit 5/A was, it could not be said that Exhibit 5/A was only inadmissible in evidence. The learned court also observed that the Honorable High Court also observed that the learned court below had sought to compute the value of the land upon taking the average of the valuation of the land as found by the land acquisition officer and the valuation as reflected in Exhibit 5 by B. And with respect to this approach, the Honorable Court held that it was well settled that a rate report is not admissible in evidence if the maker thereof has not been examined. The Honorable Court then referred to the judgment passed by the Honorable Supreme Court in the case of Srimati Triveni Devi and others versus Collector Ranchi, which has been marked as Exhibit 12 in the present case. And observe that the Honorable Supreme Court has laid down the criteria upon which the court should pass its decision in computing the value of the land. Ultimately, the court, in paragraph 19 of the judgment, took into consideration all aspects of the matter and was of the view that as no deed of sale was proved with regard to the land near about the land in question, the court was of the view that it was just and proper to award in the facts and circumstances in question by the, as the land in question was by the side of the main road and was further near the railway station, bus stand and other important offices and having great commercial value at the rate of rupees 2,500 per decimal, and was of the view that this would meet the ends of justice. The court further awarded damages on account of inconvenience, etc., with which this court is not concerned. In view of the arguments advanced by the learned counsel for the parties. The court further awarded solatium at the rate of rupees 15 per annum and interest at the rate of rupees 6% per annum from the date of taking possession of the land, that is 25/10/1972 till realization.
पुराने एक्ट के अनुसार इसको दिया गया। सबसे अगर
Just a moment. Paragraph number 10, 11, 12, 13, 14, 15, 18, 19 are quoted as under. At this, the counsel for the claimant has submitted that in the same judgment, the solatium was awarded as per the old one. Solatium 30% कब से हुआ?
84 से सितंबर 84 से। पैराग्राफ 4 को देखा जाए लॉ से थोड़ा
क्या गलती लिखा दी?
गलती नहीं है लॉ ये
हो ही सकता है
जजमेंट का एग्जिबिट 4 का
हाँ
हम केवल पॉइंट आउट करना चाह रहे हैं लॉ से लैंड लूजर की तरफ से कि इसको अगर देखा जाए इस एस्पेक्ट से तो क्या आना चाहिए। 4 में द लर्नेड लैंड एक्विजिशन जज हैज ग्रांटेड कंपनसेशन 66,550 रुपीस एंड कंपनसेशन ऑफ रुपीस 39,930 रुपये पर एकड़। यहाँ पर आप देखिए कि सुप्रीम कोर्ट ने क्या फिक्स किया 10 टाइम्स।
ऐसा है कि प्रिंसिपल ऑफ लॉ हम लोग देखते हैं किस केस में क्या फिक्स हुआ इसका कोई रेलेवेंस नहीं। द प्रॉपर्टी इज
सुप्रीम कोर्ट का जो
अब खुद तो सुप्रीम कोर्ट के लिए भी छोड़ देना चाहिए ना।
नहीं लॉर्डशिप कोई लैंड लूजर लोग बन जाए
ऐसा बात
तो लॉर्डशिप अगर हम ये बोलना चाह रहे हैं कि मेरा हम सिचुएटेड है 4 में, ये प्रॉपर्टी है 5 एंड 6 में, And
वो
three-
आपका लिखा है।
और 3 में तो हम बता रहे थे कि रेट कैसे सुप्रीम कोर्ट का क्या नजरिया है रेट फिक्स करने का उनको 1,35,000 वो 54 का जस्ट मेरे बगल में है वार्ड नंबर 3 उसके बगल में हम लोग हैं 5 and 6
इंडिया के बगल में पाकिस्तान है
लॉर्डशिप
वैसा, इसीलिए ऐसा मत बोलिए कि बगल में है। बगल इज अ वेरी डिफरेंट कॉन्सेप्ट।
लॉर्डशिप अभी सुप्रीम कोर्ट का जो व्यू है 3 स्टेट का रेट एक लिया गया सतलज कनाल में जम्मू कश्मीर का एक जजमेंट आया वो पंजाब में लागू हुआ है ऐसा नहीं है लॉर्डशिप के हम बताना चाह रहे हैं लॉर्डशिप की वार्ड नंबर 3 में 1,35,000 1954 में मेरा 1971 में 43,000 और 1971 में वहाँ 2,50,000 ये मेरा बोलना था कि क्या व्यू है सुप्रीम कोर्ट का अब लोअर कोर्ट से 10 टाइम्स अधिक दिया गया ये मेरा कहना है कि 4 को एक बार देख लिया
ये 4 में क्या है?
क्या रेट
4 भी कोट कर दीजिए।
फिक्स किया था लोअर कोर्ट ने आप सुप्रीम
That's
कोर्ट ने
right.
कहा इसको ले लिया
ये जजमेंट थोड़ी सुप्रीम कोर्ट दिया था,
जी
यही वाला जजमेंट।
हाँ ये इसी यही जजमेंट है
ये जजमेंट सुप्रीम कोर्ट दिया था वो कौन सा एग्जिबिट है?
The learned land acquisition judge has granted compensation 66,550 फिर ये हाई कोर्ट गया हाई कोर्ट से फिर ये सुप्रीम कोर्ट गया तो 2,50,000 इसमें
नहीं इसमें मंसर हसन ने सुप्रीम कोर्ट 2,50,000 रुपए फिक्स किया। कहाँ फिक्स?
ये हाई कोर्ट का है
ये तो हाई कोर्ट का है
जी
ना?
हाई कोर्ट ने दिया
हाई कोर्ट ने दिया, हाई
जी।
कोर्ट की बात।
मेरा काम है लॉर्डशिप की जहाँ जहाँ इसको बताना कैसे अभी का सुप्रीम कोर्ट का जजमेंट आया लॉर्डशिप कि 3 स्टेट का एक वैल्यू लिया गया आप बोलेंगे लॉर्डशिप तो हम कल ला देंगे ये तो हम लोग सिमिलर सिचुएटेड वार्ड में
So far as exhibit this court finds that while exhibit 4 the High Court was dealing with a case where the notification under the Land Acquisition Act was issued on under Section 4 was issued on 28/8/1971. But the location and position of the property was very different from the case involved in the present case, from the villages involved in the present case. And further, the court was of the view that since no deed of, further in the same case, no deed of sale was proved with regard to the land near about the land in question. And therefore, the court thought it proper to award compensation considering the position of the property by the side of the main road, near railway station, bus stand and other important offices, and having great commercial value at the rate of rupees 2,500 per decimal, which according to the court would meet the ends of justice. This court is of the view that Exhibit 4 is not fit to be relied upon in the present case on account of 2 reasons. Firstly, the location of the property is very different. Location, position and value of the property is very different as that of the present case. Merely because the property was situated in ward number 5 and 6, the same cannot be a reason to fix the same rate as that of property situated in ward number 4, unless the market value of the property is the same. Further, in the present case, there is an exhibit, that is exhibit 9, relating to Gari, relating to village Gari.
Exhibit 12.
Exhibit 9, relating to village Gari,
अच्छा सेल
relating to village Gari, which is the property of one of the villages which has been acquired in the present case. अब आइए exhibit 12.
May I say something?
Yes.
Submit, Manoj?
Yes. What do you want?
As per this judgment of ratio, that exhibit 9 has also not been proved.
Which judgment?
Because maker and seller, if we go by ratio of this judgment, then exhibit 9 I cannot be taken into consideration because that is not proved.
अब आप नया आर्गुमेंट मत करिए सर, आपके सामने लिखा रहे हैं, इसका मतलब ये नहीं है कि आप नया आर्गुमेंट करने लग जाइए.
ये बता रहा हूँ कि इस जजमेंट के आधार पे सेलर मेकर हैज नॉट.
That's right. So far as exhibit 12 is concerned, the same is the judgment passed in the case of Triveni Devi, which has been referred to in exhibit 4 also. In the same case, the notification under section 4 was issued on 7/7/1954. With respect to property in ward number 3 of Ranchi municipality. In the said case also, the land in question were acquired earlier, the land is question were leased out to military authorities on 22/9/1944 on a lease rent. The only question which was involved in the case before the Honorable Supreme Court was as to what was the market value of the property on the date of issuance of section 4 notification. The valuation report of the land acquisition officer adopted the principle of capitalization on the basis of 20 times the annual rental of rupees 7,200 at the rate of rupees 600 per month as the price of the land. And in the report itself, it was pointed out that the sale price of 1.085 acres out of the premises of Ranchi Club as per registered sale deed dated 1/4/1953 was rupees 41,470 per acre, which was not there. In the same case, apart from these 24 other sale transactions in respect of portions of plot involved in the same case, in respect of portions of the 25 other sale transactions between the period 1952 to 1953 were also referred in the report, which were situated opposed to Ranchi Club, and the sale price was rupees 60,000 per acre. The Honorable Supreme Court observed that the High Court adopted the price in the sale deed exhibit C/1 dated 6/5/1953 by Ranchi Club and fixed the compensation. It was then observed that though the land in question was situated on the main Ranchi-Chaibasa road, a strong objection was taken against adopting the price as a basis because it was not only half-mile away from the land under acquisition, but what was sold was only leasehold right on the land. These objections were rejected on the ground that for all practical purposes, the interest that was held or sold by Ranchi Club under Exhibit C/1 was not inferior to an absolute title. The Honorable Supreme Court then referred to the general principles for determination of compensation as has been set out in section 23 and 24 of the Land Acquisition Act and observed as under. यहाँ से लेंगे page number 6 of the judgment. यहाँ पर page number 8 का Then the Honorable Supreme Court, after laying down the general principle with regard to valuation of land for the purposes of quantifying the compensation, was of the view that the High Court was justified in adopting the registered sale deed Exhibit C executed by Ranchi Club in favor of President of India because the land is farther away not only from the land acquired but from the town, though it was on the main Ranchi-Chaibasa road. The annual rental value of the land at the rate of rupees 7,200 was also held to be not proper for computation as the rent was fixed way back in the year 1900. The Honorable Supreme Court considered the various sale deeds and materials which were placed on record in the same case, and ultimately fixed the compensation. At the rate of rupees 1,35,000 per acre. The Honorable Supreme Court ultimately held that High Court was not justified in giving 10% towards potential value because the element was inherent in the fixation of the market value of the land and could not be assessed separately. The Supreme Court further held that High Court was also not justified in disallowing 5% awarded by Judicial Commissioner as compensation for severance merely because there was an entrance gate. And the interest was awarded. Ultimately, the compensation was fixed as under: 1, at the rate of rupees 1,35,000 per acre for 4.65 acres. 2, 5% severance and 15% solution on the market value.
Subject to 1/3 deduction. 2,08,000 fix हुआ था. 1/3 deduction दिया गया development cost.
कहाँ है development cost?
After deduction 1.3 comes.
Okay.
Page
The rate was fixed after deduction of development cost to the extent of
cost लिखा हुआ भी है.
1/3. After deduction, 1/3.
Deduction.
Deduction of 1/3.
Development.
It was apparently referable to development cost. Number 2, 5% severance and 15% solution on the market value computed as per 1, and interest at the rate of 6% from the date of taking possession. The appeal of the claimants was accordingly allowed in the same terms. This court finds that the Exhibit 12 as relied upon by the counsel for the claimants those situated in ward number 3 of Ranchi municipality was certainly within the Ranchi town, and the notification in the same case was under section 4 was issued way back on 7/7/1954. The said judgment in the said judgment, numerous deeds and numerous materials were placed on record for the purposes of computing the market value, but the location and position of the properties involved in the said case is quite different from that of the properties which are involved in the present case. Accordingly, this court is of the considered view that Exhibit 12 also cannot be relied upon for the purposes of fixing the market value of the land involved in this case. so far as the quantum is concerned. अब बच्चा यूनियन ऑफ इंडिया का। साढ़े 4 बैठ गए। दो चीज बच रहा है यूनियन। आपका तो एनहांसमेंट का काम करना एज आई सी इट, अपरेंटली तो लग रहा है। अब यूनियन ऑफ इंडिया का जो क्वेश्चन किए हैं कि ज़्यादा हो गया फीस, दैट इज लाइक अदर इज कंपाउंडिंग ऑफ इंटरेस्ट, दीज टू थिंग्स आर लेफ्ट। बाकी आई थिंक एवरीथिंग वी हैव कवर्ड।
One thing will note that state highway which has been observed, state highway जैसा कोई ढूंढ के देखे कहीं है नहीं। Their submission during
ये
arbitration,
सबमिशन सारा कुछ इनका एविडेंस में आया है, आपके एविडेंस में भी आया है।
उसको जो है
वो गलत बोल दिया।
नहीं स्टेट वो उसको यूज किया गया है।
वो जो पुरुलिया रोड है ना,
हाँ
कब से है? 1932 से है,
हाँ।
ऐसा एविडेंस में आया है।
हाँ वो
तब?
पुलिया रोड है, वो है रोड, लेकिन उसको यूज किया ये स्टेट पिच रोड हैज पास्ड थ्रू विलेज लालगंज।
अभी भी है।
हाँ
अभी
अभी
भी
भी है
हाँ
और वो बहुत पहले से हम लोग जानते
अभी
नहीं
भी
क्या
है।
जो इसमें लिखा है वो सही लिखा है। हम लोग जानते हैं कि वो बहुत पुराना रोड है, आज का रोड थोड़ी। आप भी तो यहीं के हैं ना, बाहर से आए।
मंडे का 250
बस लास्ट लेग है मंडे। मंडे को नहीं रखेंगे इसमें। अच्छा मंडे रख देते हैं।
नहीं नहीं मेरे माँ का पुण्यतिथि है 7 तारीख को।
तिथि निकालेंगे।
नहीं, मेरी मम्मी का पुण्य द्वितीय पुण्यतिथि है 7 तारीख को है, तो अलग इसमें काम करना है।
As the court time is over, post this case for further dictation on Monday at 2:15.
Not seen.
कोर्ट में लिखा लिए
Not seen.
तो लिखा लिए नहीं तो ये जो है ना हम लोग का कॉस्ट आईटी बन गया है। कहाँ है यहाँ कॉस्ट आईटी बना है इसका कंप्लीट रेस्पोंडेंट अपीलाइन सबका
पूरा बना हुआ पहले
बना हुआ है कंप्लीट।
वो तो हम ही बनाए।
आपने बनाया यूनियन ऑफ इंडिया का और जो क्लेमेंट का सारा है
पेमेंट वाला वो 500।
हाँ वो 500 है, वो हम लोग बनवाए। आपको क्या लग रहा है? पिछला 3 महीना से इसमें काम हो रहा है, एक टीम से किसी के लिए लगा हुआ है कॉस्ट टाइटल बना।
लास्टली एक ही बात बोलेंगे लॉर्ड से, हम लोगों पर रहम कीजिए।
हम लोग सिर्फ लॉ पर ही रहम कर सकते हैं, बियॉन्ड लॉ रहम नहीं कर सकते।
This question is there.
60-70 हजार लोग इसमें इन्वॉल्व हैं लॉर्ड से।
ठीक है I forgot. Okay, just let me just.
Date can be fixed.
कोई बात नहीं, other side का है अभी। अच्छा लाइए आइए नंबर
Item 50.
14478. This is for formulation of conditions.
आइए नंबर 14478
And there is another
of 25 in essay number 83 of 23. Another IE is
8536 of 23. That is for stay of the execution.
वो बाद में अदर साइड के बिना नहीं सुनेंगे, अब तो हम लोग फाइनली सुनेंगे।
Yes.
This petition has been filed proposing framing of additional substantial question of law. Filed interlocutory application filed on 6/10/25. Have you served copy? A copy has been served
सर कर नहीं
to the आप other side हैं?
No,
मैं
no,
अगर settle कर
it is
to the council for the other side. बताइए कब रख दें?
second week of December after
At the
16th.
request of the learned counsel for the appellant, pose this case on 17th December. On 17th of December 25. In the meantime, it will be open to the respondents to file a response to the interlocutory application. If so advised,
And if the case can be within first
supplementary list. Supplementary list. Under heading for orders में. Orders वाले cases 4 ही बजे तक.